what are we left with? We have public authorities, government departments, in most of the cases performing the role of the bid inviting authority or the employer. They all are amenable to writ jurisdiction. And we have the CPC and the civil litigation route, the civil suits for damages. Now, can we observe that arbitration has actually taken the burden off the courts? Plain simple answer is no. Not a happy answer, but the answer is no. Section 5 of the Arbitration and Conciliation Act clearly says that judicial authorities will not intervene in the arbitral process, except in accordance with the provisions of the Act. And we have a whole lot of provisions in the Act which facilitate intervention by the courts. And that itself is important for the entire dispute resolution ecosystem when we are looking at resolving construction disputes. So, if I may say that yes, there's a inherent conflict, but yes, that is what it is. Now coming to the burden before the courts, we have Section 9 petitions. Even prior to that, quite often parties end up with a disagreement with regard to the appointment of an arbitrator. They fail to act within 30 days. The first level, parties approach the court under Section 11. So once the arbitrator is appointed, then there are also situations wherein interim relief is required. Quite often, stay is required against encashment of bank guarantee or placing some funds in an escrow account or restraining a party from terminating a contract during pendency of arbitration and things like that. So Section 9 of the Arbitration Act is an avenue which leads to a lot of litigation in relation to construction disputes. I would say pre-arbitration litigation, arbitration stage litigation, as well as post-arbitration stage litigation, because Section 9 contemplates approaching the courts either before arbitration, during, or even before the arbitration award is enforced. So Section 9 remedy remains available at all the times. Although there have been amendments in the Act, there has been more emphasis on taking recourse to Section 17 and seeking interim relief from the arbitral tribunals itself. But again, we have a lot of cases under Section 9 before the courts, so that contributes to the burden. Then there are execution petitions under Section 36, there are appeals under 37, and most importantly, applications for setting aside of the award under 34. Now 34 was meant to be a very, very narrow provision, which provided a narrow window for setting aside of the award, primarily on the grounds if a party has not been able to represent itself or the public policy. But we all know what has happened over the years, how the law has evolved across the country. And in spite of the amendments to the Act, the public policy window has been interpreted in different manner by different constitutional courts up to the level of Honorable Supreme Court. And one important feature contributing to this volume of litigation before the courts emanating out of construction disputes is the high amounts involved. You talk about the energy sector projects, railway sector projects. The quantum of claims is typically much higher than highways. The number of cases going in for arbitration from highway sector appear to be more visible, more in number. But the quantum in disputes in the railways, metros, energy, it's much higher. So all these causes, they compel the claimants or the other parties, the respondents, to take a shot through Section 34. No one wants to pay up unless they take a chance in Section 34 before the courts. I distinctly remember about 15 years ago, on behalf of the World Bank, I was studying the litigation history of NHAI, and we were doing a sampling of the litigation history of NHAI, how many cases they had lost, how many cases they won, what were the primary causes of disputes, delay in handing over of the site, relocation of utilities and whatnot. I distinctly remember during one of those meetings, Chairman NHAI told me, he said, Gagan, the regulatory framework is very unbalanced and unfair towards government authorities. I said, sir, why? He said, ये लोग रेट डाल देते हैं हमारे अगेंस्ट, हम डाल नहीं सकते. I said, they are private contractors, they are not amenable to rate. He said, what good is the arbitration clause or the dispute resolution mechanisms we have here? And that time, they were feeling quite pained, that the Honorable Supreme Court was virtually monitoring the progress of one national highway project on each and every date, because the project was stuck up since a very long time. So it does happen. The powers of the writ courts are very, very wide. So that anomaly, of course, is there. And the other thing is, there are certain kinds of disputes which still go to the traditional courts. For example, arbitrary termination of a contract at a pre-arbitral stage, or say an attempt to encash a bank guarantee. You'll find contractors either approaching the Honorable High Court under the writ jurisdiction or taking recourse to Section 9 of the Arbitration Act. Now, whether writ is maintainable or not in particular facts and circumstances, that's a separate issue. You need to make out a case of arbitrariness, mala fide intentions on the part of the government authorities, and also that arbitration has not been invoked or whatever. Quite often, we have orders wherein the Honorable Court says that please take recourse to proper remedy, and until then, this interim injunction will continue. So, to say that the burden of the traditional courts has been reduced because of arbitration, no. The answer is no. There is litigation all around prior to arbitration for interim relief, interim protection during arbitration, and then, of course, Section 34 challenging the awards. So that's my take on it.